We are live, ma'am.
All right. Thank you. Good morning, everyone, and thank you so much for joining us on this Saturday morning. Without further ado, let me introduce our speaker for the day. It is with great honor and privilege that I introduce to you Professor Marika Paulsen. She is a senior advisor at this time with the Albright Stonebridge Group, where she draws on her immense, extensive experience in public international law, international arbitration, human rights, and cross-border litigation, and advises clients on resolution of investment as well as commercial disputes with states through strategy as well as her expertise in diplomacy. She also was serving until very recently at the University of Miami School of Law's International Arbitration Institute and has been a professor of international law and commercial arbitration and investment dispute settlement. Her main area of expertise and her recognition is on treaty compliance law and her seminal work on the 1958 United Nations Convention on Recognition and Enforcement of Foreign Arbitral Awards, which is the New York Convention, is treated as the authoritative work on this convention alongside the works of Professor Albert Vandenberg. Sorry. She's also the Vice President for North America of the Global Legal Institute for Peace and Conflict Resolution Center of the University of Sao Paulo. She's also an appointed member of the Court of the Mauritius Arbitration and Mediation Center, a member of the Judiciary Committee of the International Council for Commercial Arbitration, and a member of the jury for the Princess Sabika bin Ibrahim Al Khalifa Global Award for Women Empowerment, which is awarded by the United Nations Women and Bahrain. She served earlier in her career as a counsel at Hanusiau and Vandenberg in Brussels and held associate positions at Freshfields, Bruckhaus Deringer, and Allen and Overy in Amsterdam. She graduated from the Leiden University School of Law, holds a master's in international law from the University of Miami School of Law, and has a diploma from Sciences Po, Paris, where she studied political science. She is a polyglot, speaks 5 languages, and is a member and past member of the Dutch, Bahraini, and Belgian Bar Associations. Currently, she's based in Bahrain. And if I may say so myself, Prof. Marika has been one of the biggest supporters of all the students that I have been teaching in my very short teaching career. She's very happy to accept master's applications when she was at the Miami School of Law, and which is how Professor Marika and I got to know each other. She's brilliant, and I cannot wait to learn from her in this session. Professor Marika, the floor is yours. For the uninitiated, she's going to talk about something very contemporary, very interesting, very complicated and technical. So please take it over.
Thank you, thank you. I'm now blushing again. Good morning, everyone. In Bahrain, it's about 8:30 in the morning. I've little creatures walking around in pajamas, getting ready for play dates, and I'm really impressed with the students that they're logging in on a Saturday morning. I'm not sure if I would have the stamina to do so when I was a student. So bravo and brava to all of you who are here with us this morning. Now, indeed, it's really the students that have connected us. I was a professor with the University of Miami School of Law and leading the International Arbitration Institute. And we had set up a Young IKA Scholarship. Now, IKA or Young IKA is a worldwide organization for students and young lawyers around the world who have an interest in international arbitration and international law. It's an organization that I created in 2008. And I think at this point, it has about, I think it almost has 10,000 members. And the idea was that we were going to set up a mentoring program and training workshops. And then after some time, we decided to to also add scholarships. And what was interesting that in the years that we've had the Young IKA Scholarship in Miami, we've had many Indian students, but I think I've had 2 from Jindal, which is very unique. And Suprita Suresh was one of them.
Jodhpur. I was at Jodhpur at that time.
Okay.
NLU Jodhpur, yes.
Sorry. Well, at least she comes from this group of wonderful people. And Suprita, therefore, was already a top student, having won the Young IKA prize. We all marvel at the person that is Suprita, who is very adventurous now somewhere in the Himalayas. And so from Miami, I think we all went to Washington, me working for Madeleine Albright, Suprita working at ICSID, and then somehow by pure fate, we found our way to Bahrain. Me, because I just wanted to go back home, and Suprita working at 3 Crowns. So it's very interesting how certain people just stick together. And I think it's through that we are all connected. I think it's a wonderful community that you have over there. I'm really very excited to now be part of it. As we were just discussing, this just came out, and it's the arbitration handbook for India. We've had, I think, in total about 40 authors. I worked on this with Dushan Dave and Fali Nariman. We've had amazing people from Pramod Nair and George Podan and Karuna Nundi, whom I also love. But really, I just said, I would not have been able to survive the final editing process were it not for Suprita. And we've spent many a night connected virtually until 5 o'clock in the morning, going through a chapter for like the 20th time. And here's the actual book. So, and as you can see, you see the design. This was a big deal because normally Kluwer only allows a 2-color and there is no design. And then in the middle of the night, we found the images of the sari block print, of which I have a lot of art in my house, incidentally, which I think you have seen on the Instagram. And so now we have it on the book, and that just makes me very, very happy that, it's full circle. So here we are. Indeed, my specialization is the New York Convention. That's not because I woke up one day and I decided this is what I want to do with my life. I mean, I'm not that nerdy. What happened is I worked at Freshfields. It's a very big law firm, and I'm doing this whole personal segue because there's so many students online. And it was a very big law firm, and I felt between what I had seen with the law school at Leiden University, which is a bit like Oxford and Cambridge, so very old school, I had a certain image of what law would be like. And Freshfields is big law from London. It's a magic circle firm. And it was just not what I had expected. I did not think that was what my life was going to be. So I was kind of in a crisis. And because it was led by a New York partner, so it was very much what you see in those American series, which is not a nightmare you want to live out in real life, at least not for me. And so I met Albert-Jan Vandenberg, who said, why don't you come to my firm in Brussels? And forgive me, because I did not know who he was. And then my mentor at the Freshfields firm said, well, you should read this book he wrote from 1981 on this treaty called the New York Convention. I had no idea what that was. I saw the book, I read one page, and I thought, I'm just not ever going to get through that book. And so somehow I did get the job. And long and behold, of course, Albert-Jan Vandenberg, his mentor is Pete Sanders, the author of the New York Convention. He is the undisputed leading authority on the New York Convention, has written the book, assists clients, does now the Yukos case, teaches on it. I mean, he lives and breathes the New York Convention. So needless to say, that became part of my portfolio. So it wasn't a real choice. It wasn't because I knew anything about it. It's just life just works like that. So that's how that journey started. Also, just like I have decided to enable Suprita to just jump off a cliff and dance and work with me on this book. I've sent her to speak at conferences alongside Emmanuel Gaillard and Anna Junibret. You just have to do it. And so this is what Arbitration did with me. So I was 24 and he would send me out to teach at Erasmus. He would send me to lead meetings at IKA, to do things at the Netherlands Arbitration Institute. So he said, jump off that cliff and try to fly. And so I know that can work if you have the right personality for it. And so that's how I really had to learn quickly about the New York Convention. Then I moved with my husband to Miami, not really knowing what I was going to do, because I still had that trauma of working for a New York partner, and I was very reluctant to work at a US firm, which I did do that eventually. But anyway, and so Arbitration said, why don't you teach the New York Convention with me in Miami? And so that happened, and then it was time for a second edition of his book, but he's very busy, and Kluwer said, why don't you write a book? And so this is how it happened. So this is just, the lesson learned is you can make all sorts of plans and a wish list and put in your head that you want to do a certain thing, like investor state arbitration, which is so popular, right? Or human rights, or going to the International Court of Justice. And you can put that in your head, but sometimes you also just need to be open-minded and look at what comes your way. And then maybe after 20 years, you actually realize that you don't like it at all. And that would be a very sad day. So anyway, I still like the New York Convention because it's a living, breathing document. Now, the New York Convention is 60 years old. So I'm just sliding into the New York Convention like that. It's 60 years old. And what is important to know is that most people, and with the gossiping, and people say, when people say. So when I say most people, the question is really, well, who is that? So I'm now talking about the international arbitration community. When I talk about the international arbitration community, I'm very aware that I'm talking about, let's say, the group that goes to the IKA conferences, that goes to the ICC conferences. So you're talking about, Paris and the London crowd and the New York crowd and the Miami crowd. And they all sit together, preaching to the choir and kind of applauding the New York Convention as this amazing success. One thing that even happened, and forgive me for my sarcasm, is that last year an effort was underway by some who are involved with IKA to say this New York Convention and the monitoring of the New York Convention is so important for international trade that we should submit Pete Saunders and IKA for a Nobel Prize. And they actually were in the process of collecting signatures and writing a letter, and all because the New York Convention is such an amazing United Nations treaty. And this is really where I feel that we in the arbitration community have lost perspective. So what's interesting is that most people think it's great, whereas Albert Jan Vandenberg, who is the authority, and myself, we kind of feel that it's time to revisit the New York Convention. Now, why do I say this? It's a text from 1958 that came about after World War II, and it's outdated. I mean, there is really only so much you can do with words to turn them into something else. So for example, let's talk about alternative medicine, right? There are a lot of people who believe in it. I myself do believe in Ayurveda, but if I have a medical problem, I will still go to a doctor. My father is a doctor, and we were discussing these alternative health protocols, and he said to me, look outside. Is the sun yellow or is it bright purple? I said, well, it's yellow. He said, yeah, it's not bright purple. And these people are going to tell you that it's bright purple. So this is a doctor not believing in alternative medicine. If you look at the text of the New York Convention, and Article 2 says it's in writing, it really means in writing. It doesn't mean that if you and I are now communicating over the Zoom, and we're going to say, we want to write a book together, and I will say now, well, okay, so if we have a problem, should we then just arbitrate? And you say, yes, okay. somebody explain to me how that is in writing. So there's only so much we can do with the words of the New York Convention. So that's what I want to talk about today, that it's a treaty that comes after World War II. And now we are in 2021, and we're going to talk about blockchain. Now, disclaimer, I'm not going to date myself that I'm so old. Obviously I'm not, but I am old when it comes to technology. So there's some people who really love it, right? To get the new gadgets and well, you know, all the stuff that you do with technology. I'm the one who's absolutely terrified of it. So I've noticed with Zoom, my anxiety levels have gone up. I'm definitely not afraid of doing public speaking, but the Zoom, I check my router to see if the little light is green. I have all sorts of cables plugged in. I bought ether cables, and then I have another device, and then I burn some incense and I pray that I hope this will just last for 2 hours. So I'm not one of those modern people. And then I had a student from the University of Miami who said, you know, we're developing blockchain. And I'm thinking, okay, I just, you know, I mean, it means nothing to me, that word. I mean, we've all heard about Bitcoin, and the only thing I think about Bitcoin is, well, I'm just not going to look into that any further because it means nothing to me. These words mean nothing to me. And so he said, we're developing blockchain ADR. Would you want to be part of this? And somehow I said yes, because I thought I always want to encourage my students to be pioneers and to be those disruptive change makers. So I forced myself a little bit. So I do feel that I know more about it, but also the more I then learn about it, the more I understand that I really don't understand it. So please forgive me on that part of the blockchain. I have documents from these students who have set out what it is. And because I'm so terrified of technology, I'm going to just read that out. Because if I will interpret it, I will probably butcher it into something else like a purple sun. So now we're going to start with, there is a dog barking here, and I have people in the house who are supposed to, you know, keep the peace, and that's not happening because we're having a Bridget Jones moment, and Snowy is a Bichon Frise who sees something that's not real and starts barking at it because he believes the sun is purple. So I apologize for that. Okay, now the success of the New York Convention. The New York Convention perhaps could lay claim to be the most effective instance of international legislation in the entire history of commercial law. This was Lord Mustoe in 1981. And I know there are many students listening today who weren't even alive back then. Some come from the 2000s, can you imagine? So that's before, you know, what we call, like, before you had the Twix, it was the Raider and all those things. Okay, anyway. Then this landmark instrument has many virtues. It has nourished respect for binding commitments, whether they have been entered into by private parties or governments. It has inspired confidence in the rule of law, and it has helped ensure fair treatment when disputes arise over contractual rights and obligations. International trade thrives on the rule of law. Without it, parties are often reluctant to enter into cross-border commercial transactions or make international investments. Now, that is Kofi Annan, the former Secretary General of the United Nations. So there are titans of the world who, not even part of the international arbitration arena, who have really hailed this document as one of the biggest successes. The New York Convention, as I said, is over 60 years old. At this point, we have almost 170 contracting states, almost everyone in Latin America. In this part of the world, the MENA region, we're doing well. In Africa, we're doing well. So really, even in the last year or 2020, we saw so many, how should I say, unusual states signing on. And one really wonders why? Why now after 60 years? Thousands and thousands of decisions have been reported by IKA in the IKA yearbook on those decisions. And of these decisions, most of them are judges granting the recognition and enforcement of foreign arbitral awards. So why do I start with this? Because I feel it's my obligation to do so. whenever I criticize the New York Convention, I immediately get that as a rebuttal. So I thought, let me get that rebuttal out of the way from the get-go. So it's a huge success, right? And for that reason, we no longer look at the actual text or at the actual decisions or at the implementing acts or at what judges do with it. So for those who are interested in the New York Convention, there are cases that focus on what do you do with an award that has been set aside. So this is an arbitration has taken place. The losing party is obviously not happy having to pay money under that award, and the losing party will hire a lawyer to go to the local courts to file for what we call the annulment, the setting aside, or vacating the award. So basically to destroy and get rid of the award. And then in the olden days, one would say, well, that's the end of it, right? There is a Latin expression, ex nihilo nihil fit, out of nothing comes nothing. Albert Jahn would say you cannot resurrect a ghost. And some case law followed years ago in the United States and in France. Cromalloy, Hill, Martin, those who do arbitration know too well what those cases are, where there was some sort of enforcement of these types of awards, but France actually opts out. So it wasn't that straightforward. Anyway, that moment came and then it passed. And then people said, you know, at this point in time, annulled awards are simply not being enforced. And then came Pemex and Yukos. Pemex is a Mexican case. So Pemex is a state-owned entity that entered into an arbitration procedure against Comisa. So Pemex is basically, you have to look at that as being Mexico, and Comisa is in a way the foreign investor. The arbitration took place in Mexico. Comisa, the foreigner, wins, and gosh, what happens? Surprise, surprise. It goes to the Mexican courts and the award is annulled. Now, little tricky part in that case scenario is that after the award was rendered, the Mexican legislator enacted a law, and that law was applied ex post facto, so retroactively, to get rid of this award. So one would call that a denial of justice. So that award finds its way to the United States, where a lower court American judge says, I am not recognizing the annulment, I'm enforcing the award. And what followed is years and years of litigation and people writing about it, including myself. The other one is Yukos, a case where I was at the time even still involved. Yukos against Russia, a $50 billion award. I think most people, even those who don't do law, know about this. The arbitration took place in the Netherlands, in The Hague. Yukos wins this case, big victory. Of course, Russia goes to the Dutch courts. Setting aside follows, but then the enforcement, well, we're still in the middle of it. So the enforcement procedures continue across the globe. Then there's Court of Appeal, it's overturned, now it's going to go to the Supreme Court. So there's also the appeal on a setting aside. And so the question again is, can you enforce that annulled award? And so now courts around the world have developed theories to circumvent that principle of an annulled award no longer exists. So we get into the debate of sovereignty. It's really a clash of courts, courts of origin and courts of enforcement. And so this is where Fali Nariman says, sovereignty is like billiard balls. They collide often, but seldom do they go in the right direction. So we are in the midst of a sovereignty battle. So that is the New York Convention. Now, I want to, from that sort of specific law scenario, kind of segue into technology. So we sort of set the stage where we are with arbitration, with awards, with annulment, with the New York Convention. Although it's on paper a success, there are now many specific problems that surface that are now left with the courts around the world to just interpret this 60-year-old text and try to adapt it not only to the modern times, but also to try to find solutions to all the problems that courts have been confronted with using those words from 1958. So that's where we are, 2021. Then technology, and really, if I would have talked about this in 2019, it would have been a different discussion, right? We already, back in 2018, 2019, we would talk about artificial intelligence. We talked about email traffic. We talked about e-commerce, e-trade, e-arbitration, electronic discovery. What is the role of electronic discovery in international arbitration? We made jokes about the Oculus Rift. And I remember at the time we were already talking about virtual hearings and asking ourselves, what if an arbitration is completely virtual? And what I find interesting is that in 1999, the good old 90s, Gerald Herman, who was also the president of IKA and actually is the real mastermind behind Ansator. In 1999, he gave a Freshfields lecture and he made jokes about the virtual world. So he said, oh, what if one day we have cybertration or arbitration, where an award is rendered into outer space and is rendered by the arbitration mediation center. And where then is that award made? And his cynicism was flowing over. And the point he was trying to make is it will simply not happen. Ironically, here we find ourselves, right? We have virtual hearings. I remember the days with Albert Jan that when he would act as arbitrator, the courier would arrive with a truckload full of boxes that contained documents, from all the statements to the exhibits to the crossers and God knows what have you. And, you know, people have accepted that submitting these things electronically is fine. So you can submit statements to the institution electronically. Awards can be written on your computer and can be submitted electronically. We have electronic signatures. So we already took that step: emails, e-arbitration, online arbitration, virtual hearings. And the question of where is the award made is now more a question of the legal seat and not where arbitrators physically are, right? So if the seat of arbitration was, let's say, the Netherlands, you can still have one arbitrator living in Washington and one living in Dubai and one living in Brussels. And they'll find a way to write and sign that award, except for actually Dubai, where under domestic law, you have to come to Dubai to sign that award. So we're there. In addition to artificial intelligence, there's a lot of discussions about robots. So the artificial intelligence robot taking over, not just in law, but, you know, everywhere in the world. And then we have the blockchain. So most people will think about blockchain and they'll think about Bitcoin, but what we need to understand is blockchain isn't Bitcoin. Blockchain is a carrier that was used for Bitcoin. And then there's social media. And I know that most students, for you, social media is something that you know, it's like oxygen. I think I even see it with my son who's 10, who's still not allowed to touch it. But I know there are 10-year-olds who have their own phones and they have their own Instagram accounts. There's actually a lot of debate on legislation, whether or not that is allowed. But I think for students, the first thing you do when you wake up is check your social media. And you know, we come from the time, now I'm dating myself, but who cares, that when we had friendships, you know, in high school and law school, that would actually, you know, it's really interesting, but it would be this in-person thing of a friendship. Yeah. And we did not have cell phones. There was only like the fixed, which I have actually one here. It's like a fixed phone. So you have to pick that up and see if nobody else. In my dorm, there were 12 girls. So that was very hard to pick up the fixed phone. So you would actually have to go out there and meet with each other. And yeah, and that was possible. So those, and also really in high school, we would exchange little notes that you write with this thing that's a pen. You see, this is a pen. And then there's paper and you write on it. And then you know, like whoop, like that. So it's not the on your Instagram, which by the way, I'm totally addicted now, but that's besides the point. So anyway, so I only joined Instagram in May, and I joined Facebook in May. And then I sent a message to somebody, I just joined Facebook. And this person said, I never thought that I would still get that message of somebody saying, I just joined Facebook. Like I'm a relic who only now joined Facebook. I do think it's fantastic. I think it's a fantastic portal that you control your own storyline and you are not bound by institutions or, you know, PR people at firms who tell you what you're allowed to say and what you're not allowed to say. I think it's amazing because it gives me a direct way to communicate with my students rather than through the US law schools where there are all these rules. So I like it, but I do think it's very dangerous. Now, with the pandemic, and that's why I am sort of tolerant with the students, with the pandemic, this is now the forced reality, right? Some countries are now coming out of it. Some countries are confronted with a third wave. Some countries just have had a wave from the beginning and it's never been good. So now the reality is that thank God for Zoom and email and FaceTime and WhatsApp and social media, we're still all connected. And so now this technology is in a way our savior. And with this pandemic, you will have all noticed that arbitration has changed overnight. So overnight, instead of arbitration, the community and the stakeholders and the institutions saying we're taking a break, in no time they switched to virtual. So whether it's ICSID or the ICC or the COMCCBC in Brazil, or and I'm sure also the Mumbai Center, immediately they said, we're going to do virtual hearings. Now this is something, and I'm taking my time because I've got time. This is something what's really important for students to know, because it's for you hard to imagine that it could be hard, okay? So you would think, what's the big deal of a virtual hearing? Now, you have to understand that you're going to have 3 arbitrators, a secretary to the tribunal, the parties, counsel, the whole counsel team, all the witnesses, the experts, plus the institution, and they all have to be logged in. Zoom is not a safe platform. So there are other, what's it called, Cisco and other, you know, of those carriers. And they are used by ICSID, so safer ways to have this hearing, because most of these hearings are confidential. And then what you see is you have these arbitrators, instead of sitting in a hearing room in Washington or Paris, they are sitting at home behind their screens. Everybody's sitting at home behind their screens, and they are trying to conduct a hearing. Now, you would think that's fantastic because you're saving costs, there's no travel, everybody can be there, easy peasy. This is not true. These arbitrators spend days, if not weeks, working with IT specialists to figure everything out. These arbitrators overnight need to learn how to look at the screen and look at the counsel presenting an argument. Then on another screen, they need to pull up the exhibits. They have to be able to listen to the witnesses, or when they are being crossed, they then have to be able to ask the right questions and look at the exhibits. And many, many times something goes wrong. Even with odd situations where one arbitrator is in upstate New York and gets caught in a storm and no longer has an internet connection, gets in a taxi or an Uber trying to drive to downtown New York to get a different internet connection, which means that for 2 days, everybody has to pause. This means maybe 50 people who all of a sudden have to wait. So you also have the situation that one arbitrator is 2 o'clock in the morning, the other one is at 6 a.m. So there are many who think this is a very positive development, but there are also many who say, you know, we should go back to in person. It also really depends on the country. So in Brazil, apparently, the virtual arbitration option is fantastic. They have the setup. They haven't had a lot of glitches. Whereas, for example, with actually in the West, we've seen that a lot, it's sort of Murphy's Law, a lot of things go wrong. So what you see is some institutions were ready and they had, how should I say, the internet, the tech, they were ready to go. They already had the facilities. Here in Bahrain, the BCR has had the facilities for years. I don't know what the situation is with the Indian arbitration institutions, but some were more ready than others. But you do have to understand that many of these arbitrators are of a certain age and they are simply not used to this. And then what you get when you look at due process, these arbitrators are quite focused on making just everything work, that they think, okay, I'm just not going to touch, if I'm already listening to a witness being examined and I'm seeing an exhibit, I'm not going to try to open yet a third pathway to look at my transcript because they're afraid things crash. Whereas in the real world, they would be more comfortable. So it does really distract. So there we are. We already saw this rise of the tech world. And now we were all forced to jump off a cliff with the pandemic. So that's technology. So I'm just trying to set the stage for where we need to go, or where the students need to go, because honestly, it's going to be more of the students' problem, right, than my problem to deal with this new future. So there we are in geopolitics. That's my little third bucket to set the stage. And again, you know, whenever you thought it couldn't get any crazier, it gets crazier. And if I would have prepared my speech 2 weeks ago, a week ago, on Monday, or yesterday, it would look different every time. This is how fast history is being written. We moved from Miami to Washington in 2016. Again, I'm often US focused because I've lived there for so long. And we were very excited because we thought we're going to be part of history. It's going to be the first female president of the United States, the most powerful nation in the world, the leader of the free world. We obviously had a lot of friends in that group of people and thought, gosh, this is going to be so exciting to be in the middle of where it's going to happen. And then Trump won. It's interesting because when you have this conversation in the US, I don't even have to think about what I'm saying about that politically. Here in the region, I have to think twice. But it's safe to say that the world sort of came to an abrupt halt for many people when Trump was elected. The hope was still at the time that he was going to appoint a good team of qualified people who had experience. Well, that then did not happen, and things happened very fast, both internationally and domestically. So this is a man who is, well, or his people are convinced of the nationalist way of governing, who push back against internationalist and international organizations. And so what we saw immediately, TTP is dead, international treaties, international courts, the Paris, climate. I mean, the whole world sees climate change happening, you know, under their eyes. And here we have Trump, who will say, no, the sun is really purple and there is no climate change, right? So, because he lives in La La Land. And the world changed overnight from a geopolitical and human perspective, and international law changed overnight. And so we all kind of had to scramble with, you know, where are we now? What are we doing? We knew immediately that NAFTA was over. We knew that. And now we do have the USMCA. I remember in that time, it was like a wave, right? So it was Trump, and then we went to Latin America with Bolsonaro and Obrador. In the Netherlands, there was even the elections where Geert Wilders almost won. So we see sort of the extremist views, we see the nationalist views, and we see sort of the push against international organizations. At the time, the co-chair of my firm was Secretary Gutierrez, who was Secretary of Commerce under Bush. He's a Republican. And he gave a keynote lecture in Miami at the university where he talked about this. And he said, I am a Republican, but I'm against Trump. And what he described is when you look at Trump and Obrador and Bolsonaro and others everywhere in the world, we see a wave that pushes against this sort of international collaboration, that pushes against the concept of the international rule of law, that puts their own people first. I then was in Sao Paulo with the Global Institute for Peace Studies, and we had some roundtable discussions and panels with former heads of states. We were there with the former head of the Inter-American Development Bank, the former Prime Minister of Spain, former President of Brazil, with Beatriz Paredes, who is one of the leading Mexican politicians, and they discussed it. And they said in 2000, that was 2017, they said, this is a concern because there's like a wave that sort of ripples through the world, but it's also kind of, it comes in wave as in this happens, but at some point it will go back to the other way. So the pendulum just swings back and forth. And at least for the United States, that was true because then Biden, after 4 years, won the election. And he immediately tried to undo a lot of the work, as in going back into the Paris Accords, et cetera, et cetera. So they were less worried, saying this is just how the history geopolitically works. Okay. Now, many of us already felt that from a geopolitical perspective, between 2016 and let's say 2018, the world was in turmoil, right? Little did we know that we were just at the eve of the global pandemic. And I think that when the pandemic started, which obviously depends on where are you in the world. So for us here in Bahrain, it was about February, March 2019. I think many of us and therefore governments thought we can beat this by the summer, right? And now we are in 2021. And one lesson learned or one observation is to see how governance can fail, right? So Madonna, sorry to refer to her, has said the pandemic is the great equalizer because it puts us all in the same little bucket, which is complete and utter nonsense. Because one, if you have access to different type of healthcare, if you can afford private clinics, if you can afford to go to your, what should I say, beach home and kind of, isolate yourself, if you can afford to have live-in staff, this is the absolute opposite of the great equalizer. But let's then even look at, so let's not make a distinction between the ultra rich and the normal and the poor. Let's just look at countries. In my country, from the get-go, the government took care of us. So they locked down to make sure everybody was safe. They focused on healthcare. The minute the vaccines became available, it became available for everybody here. So we never had a shortage of anything. I remember back in 2019 with my colleagues back home in the United States in Washington, who were in proximity of somebody who had COVID, who had all the symptoms, who simply could not even get a test. So it really does depend where you live, and it really does depend what the government does. And this is not only what the government can do, it is a question of what the government is willing to do. It's a policy question. And this is where governments were really confronted with how good are they in governance? How do they make their policy decisions? What is their political structure? Some have a cabinet and then they have a parliament. Some have the cabinet and then they have Congress. We all know we have various systems in the world of democracy. There are different governance models. And then there's the voice of the people. So how important is it and how far reaches the power of protests, which you have in the Netherlands? So some countries have done nothing because either it was policy or governance or they just couldn't. And some have gone to another extreme of locking down completely. And so this is again where I go back to those billiard balls. the global pandemic really shows that despite the efforts of the World Health Organization, that it is impossible to reach some international agreement as to how are we, as let's say a group of countries, not even at the level of the United Nations, but how are we going to set a body of rules that can be enforced together? We're not even there. It's all being handled domestically. And then there's the question of, even if we have a set of rules, how do we enforce them? And anybody who tries to get on a plane knows, because you will go to a flight attendant at an airport and she says, you know, I have this patchwork of rules per airline, per country, per destination, and everything is different. So this is really a moment where we can see how the international rule of law can fail completely. And that at the end of the day, no man is an island, but sovereign territories in a way are. And it's ironic because this virus crosses every imaginable border, yet the borders are set when it comes to the rules. So geopolitically, we are in the midst of, one would say, a crisis. Geopolitically also, you know, the world has followed the humanitarian crisis unfolding in Afghanistan, and many organizations are kind of scrambling to still do what they can do. So that's where we are in the terms of the New York Convention overall 60 years, in terms of technology, which will change again tomorrow, in terms of geopolitics, which will change again tomorrow. So now I want to do my bad thing, which is to tear the New York Convention apart. So, and let me just take this text font away. So, okay, now I know I have a lot of students from different levels, so I really apologize when it's going to be too basic, but I'm just nervous that if I don't start with the building blocks, I might lose a lot of students, okay? Now, so I'm just going to quickly set the stage for what is the New York Convention, and then I only want to dive into Article 2 and Article 4. So I apologize for those who are interested in Article 5. That's just not part of the blockchain, okay? So the New York Convention is this treaty, United Nations 1958, for the enforcement of awards and the recognition of arbitration agreements. It has 7 articles that matter, yes. Article 1 defines the scope, which is actually important for blockchain. Article 2 is for the recognition of arbitration agreements. Article 3 sets out basically the heart of the New York Convention, the core of the New York Convention, because Article 3 tells the reader, i.e. the court, an award is binding. And this is very important because it's the presumption of validity which affects the burden of proof. Now, that Article 3 of telling judges of these contracting states to say the award is binding is set out further or elaborated in Articles 4 and 5. So the drafters of the New York Convention said, we want to promote international arbitration. So we want all these contracting states to, in principle, accept arbitration as a good thing. And how do they do that? Well, this was Pete Saunders. They say, Article 4, if you have won an arbitration, you take your award, you take your arbitration agreement, those 2 documents, and you can go to any court in any of those contracting states to get it enforced. So that is Article 4. Article 4 has sort of a minimum set of documents that you have to submit for the enforcement, in principle. Then there's Article 5, because sometimes you do have a situation where a due process was violated or the arbitrators really were not appointed properly. At the end of the day, arbitration is unregulated. There isn't really a system of checks and balances. So you do need to protect the defendant's rights as well. And that is Article 5.1. So if there really was a due process violation, or there was no valid arbitration agreement, or the arbitrators were just not appointed the way they should have been, et cetera, you can rely on those refusal grounds. And Article 5.2 is, again, that sovereign billiard ball. the drafters understood that since this is an award that's can travel the globe, they still wanted to be able to say, well, wait a second, you award, enter our territory. We still have our own concepts of public policy. And I'm sorry, but there are some awards that just violate what we think is moral and just. So Article 5.2 has that public policy exception. And then we have Article 6, which is actually something that isn't really that important in practice, but the drafters thought it was going to be, which is sometimes you have a situation where the award has been rendered, the successful party will immediately try to enforce, but the losing party is in the midst of a setting aside procedure, but no decision has yet been rendered on the setting aside. So it's pending, and that's Article 6. So a court of enforcement can say, well, okay, I've got this paper here, I'm supposed to enforce this award, but wait a second, in that other country, another judge is looking into whether this paper is really good or not. I'm just going to wait. So that is staying the procedure until the setting aside decision has been rendered. And then we have 7, which ironically in my book, I call it the trump card. This was before 2016 when I wrote it, which is if there's anything that's more favorable for enforcement, you can opt out of the New York Convention. So those are the 7 articles. Now, I want to look at Article 2 and Article 4 for the purposes of the blockchain. So Article 2, and this is, again, whatever I rambled about at the beginning of this lecture, it really did have a purpose, because I said at the beginning, the sun is yellow and it's not purple. In writing is in writing. So you have to, well, here it comes. I don't even have it. In 1958, so, you probably have to watch movies or something, but you have paper and pens and you write and you sign. What happened back in the days is, so let's say I have an arbitration, a contract with arbitration agreement, and I've signed it. And then how do I get it to the other party? I will use a telegram. Yeah, it's called a telegram, which, gosh, I don't even know how. I might have never seen a telegram, to be honest. But yeah, I don't know how to even explain what that is. Just actually as weird as a blockchain. But anyway, there's a telegram that, I don't know, is given to the other person, or a fax. Now, faxes I grew up with. So a fax, you might find it in an antique store. I remember this because you have a phone, a telephone that has a fax part of it, and you put a document in there and it just rolls through. And then somebody else who has this other fax machine, it rolls out of there. So the students might actually find that very interesting to have, just like old typewriter to play with or something. So back in 1958, when a contract is concluded and you sign it, you kind of share it through a fax. So when I worked at Freshfields and we had to wait for, let's say, a document of the court, the court would fax it to the office, and then I would pull it out like that. So that's 1958. And so in writing means a fax or a telegram. Now, Article 2 says the arbitration agreement shall be in writing, and that means either an exchange of faxes or telegrams or an offer and acceptance. So a signature of both parties. So either way, it's all this hard copy world that they lived in. Now, very soon, this became a problem because already, let's say in the 90s, right, people use, well, we didn't have email, but I think we did have electronic things. And soon enough, you have electronic signatures, you have electronic concluding of contracts, and you have emails. So UNCITRAL then created a recommendation saying that way of communication, should I call it communication, is not limited to faxes and telegrams. It can also include electronic communication. Now, this is a problem because what is the status of a recommendation? It's not like rewriting the New York Convention. So you have to get very creative with the text of the New York Convention to say it can include anything. So can it include social media? Can it include blockchain? Can it include Oculus Rift? So Article 2 demands that an arbitration agreement is actually a signature or it's an exchange in writing. And in today's day and age, when business people do business, even let's say in construction, you get the contract through your email, you write a response saying it's okay. Sometimes with construction, you have drawings that you literally have to put your signature on, but it's we're moving away, and especially now in times of the pandemic, we're moving away of that sort of in-person hard copy way of concluding contracts. So that's Article 2, that's just massively outdated. And then Article 4, where I explained you have to have an award and an arbitration agreement. Let me explain to you what Article 4 is really about. As Rita would know this, any student who has tried to do an LLM abroad, especially going to the United States, you will have to apply for a visa. Now, if you apply for a visa in the United States, you will have a safe full of documents from your records to your passport to God knows what have you. And then you have to go to an embassy. And then there are issues where they will say you have to have this certified or authenticated, which means you will have to go somewhere like a consular agent to get stamps. Right? Most of us have been there. It's the reason why you would say, I'm just going to stay where I was born and this is where I'm going to get a job. And I'm not going to be adventurous, because you will find yourself faced with these civil servants who will say at 5 to 5, my little guichet is closed, come back like in 2 weeks' time. And then that person will say, oh, you don't have all the documents with you, so I'm not giving you your stamps, come back in 2 weeks' time. And that is Article 4. Every time when I try to explain this to my students, I give this as an example, and then they know it's a headache. So the problem is the following. How many parties who have won an arbitration have the original award? Most of them don't, because the institution gets the original awards signed, and even that we now are with electronic signatures and electronic awards and God knows what have you. But the parties get a copy. The same often with an arbitration agreement, that you probably just have a copy. So if it's a copy, you need to have it certified that that copy is really a copy of the real thing. Let's say, signatures of the arbitrators, somebody needs to authenticate that that was the real signature. If there is a translation, then somebody needs to certify that this is a translation and it's official and it's a translation of the real deal. And this sounds really simple in an article that's being drafted by the drafters in 1958, but that became what I call it, the Pandora's box. So if you are representing a client and you want to enforce an award and you want to enforce it in 5 different countries, you need to ask yourself who, I call it the W's, who will certify or authenticate? Is that a consular agent? Is that a notary? Is that an embassy? Is it somebody at the court? And where? Does it have to be in the country where the award was rendered or in the country where you seek enforcement? And if it's the country where you seek enforcement, then it's in multiple countries. But then there are deadlines. So what we've seen in practice, when you study the reported cases under the New York Convention and Article 4, ironically, most successful parties have not been able to comply with Article 4. So they don't have the full translation, or they don't have all the authentications of the signatures, or they only have certified a part of the award. Now, you also need to understand, and those who are juniors at law firms know this, if you have to translate and certify a full award, that could be like 500 pages, one, that takes a lot of time, and 2, it's very expensive. And so sometimes what happens is that only a part was translated and only a part was certified, or not everything was done, or apparently it wasn't done by the right agent. So these courts are confronted with not a whole set of documents. And so then the question is, what is a court going to do? Is a court going to say, just like these civil servants when you're trying to get your visa, oh, sorry, but on page 56 of the 600-page award, you forgot to authenticate or to certify this or that, blah, 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 blah. Or are you going to say, listen, come on, this was a valid award. I can see from what I have here that there was an arbitration agreement underlying as the base of that award. I'm just going to step back as a domestic judge, and I'm going to grant enforcement. So what we've seen around the globe, that most judges are practical, but again, this is where Article 4 falls short. And there's only so much we can ask from judges. And it is difficult for the successful party to really know how to navigate the requirements of Article 4. So in Article 2, we see the text is really outdated. In writing simply does not happen anymore. We see that the UNSTRL recommendations can only go so far because they're soft law. At this point in time, we still have to see a decision where a court relies on the UNSTRL recommendations, and we're going further and further and further away from anything that's in writing. So we will be moving into a virtual world of concluding agreements, including these arbitration clauses that, you know, the drafters couldn't even have made up. They didn't even know what a BlackBerry was in 1958. And the students today probably don't know what a BlackBerry is, so there you go. And then Article 4, ironically, it was drafted in a pro-arbitration way. So it was drafted in a way, let's make it easy for the successful party to enforce. But then in the execution of Article 4, it turned out Pandora's box, because it's like getting a visa to go to the United States. So, or now, you know, when you want to travel, we had somebody here who wanted to travel to India, and we helped him, and we had a vaccination passport, we had the travel documents, we had the visas, we had the test. He missed a flight because apparently he also had to fill in a hard copy health declaration that wasn't on the website. And then he had to come back the next day. Now he traveled, and now all of a sudden India came off the red list and it wasn't necessary. So now you can even say it's like traveling. How do you know that you have on all the documents that you need to travel? And that's what it's like to enforce an award and submit this award and arbitration agreement. So this is why I have said that, and I'm not even getting in the drama that is Article 5. I have said it might be time to revisit the New York Convention and to say soft law is not enough, and maybe we do have to have a new type of treaty. But until we're there, we have to get creative. And that's where I'm going to segue. I'm just building my case here, segue into the blockchain. Now, those are all the problems with the New York Convention. There are also many, many problems in the world of international arbitration. So some of you might have followed, this is now some years ago, some of you might remember when the PCA, the Permanent Court of Arbitration, got hacked. I don't know, this was, oh my God. What was interesting is that I have to be careful because this is Zoom, it's not secure. Anyway, PCA, Permanent Court of Arbitration, administers not only state investor cases, but also state to state. And so there was one case going on, and the Chinese intelligence service had hacked into the server of the PCA, and through that other data got revealed. In another case where it turned out one of the judges had some massive conflict of interest, where he apparently had all sorts of communication with one of the parties. So obviously his career was over. But what it revealed was how vulnerable the PCA is to cybersecurity. And I think to this day that still hasn't been resolved. Now this was before the pandemic. Now we see all these institutions have moved from in-person hearings to virtual. Like I said, Zoom is not secure. When I speak over Zoom or WhatsApp or social media, I'm always assuming somebody can, listen along who's not supposed to listen along, but who's doing it anyway. So with these hearings, and again, institutions try to find safe carriers and safe platforms, but we tried to look into this with IKA, where we were creating a judicial virtual forum, and we worked with our IT master where Albert Jan said, I want something that is like FBI proof. It's impossible. It will always be a possibility that you can be, subject to hacking. And so this is where we really need to find a new virtual electronic way. And now that I've convinced you of the drama of that is the world, I can get into blockchain. So this is because I really don't understand it. So I have to, we discussed this with Martin Hunter, who is also an editor of our book. He is a living legend of international arbitration. He's actually the founding partner of arbitration at Freshfields. He is the author of the legendary Hunter and Redfern book. I mean, if you don't know him, why are you even logging into an arbitration event? Boom. So with Martin Hunter and the students of the University of Miami, we had this event in Sao Paulo. And then Martin, oh my God, Martin with his glass of wine, and he's now 90 or something, said, what, blockchain, what is this? This is a chain of blocks. It's nonsense, just like disco, very from the United States. So he absolutely rejects the concept of blockchain. Okay, I'm gonna read this out because I couldn't say it any better. Yeah, breathe in, out. Until Satoshi Nakamoto's innovative Bitcoin white paper, digital technology was merely centered on an internet of information. With the Nakamoto's groundbreaking work, which established the foundation of blockchain technology, the world now has access to an internet of value. This digital revolution will usher in a new platform to reshape the world of international trade, and more importantly, transform the order of international commercial relationships. Today, most interactions use a trusted, now you have to pay attention, trusted intermediary, such as a bank, agent, or mediator to complete transactions. Segue, we have institutions who administer these arbitrations. The excitement surrounding blockchain is related to a new reality where nearly any transaction involving an exchange of value, be it information, money, goods, or property, can be conducted securely and efficiently with blockchain technology. When layering applications such as smart contracts on top of the blockchain, its full potential can be realized. If smart contracts fulfill their promise, parties will enter into contractual relationships regardless of jurisdictional boundaries without the need of intermediaries and perhaps courts. So now we are going to move blockchain to arbitration by using smart contracts and blockchain as the carrier for the entire arbitration, from the arbitration agreement to the award. And this is how it works. A private blockchain application that enables parties to resolve their disputes under a secure, immutable, and transparent protocol for capturing negotiations, terms of a resolution, and the identities and agreements of each of the parties, as well as where every detail of the agreement would be available and traceable throughout the dispute resolution process. Now, so this is how it works, how I understand it. So, okay, this is a phone, yes? Okay, so the phone has internet and it has WhatsApp and it has email, and that's a carrier. So the blockchain, so okay, let's say the ICC, right? So the ICC has a server and it has email. And so the ICC will probably have a copy, electronic copy of the arbitration agreement. The ICC will get all the statements. The ICC will get all the exhibits, will get all the affidavits, will get the transcript, and ultimately the award. And they, many still keep hard copies, but they also keep it on a server, just like the PCA that has everything on a server. What we now see is that that server can be hacked easily. So let me get back to the world of writing and hard copy and the world that we accept. So we met with engineers in Sao Paulo, and they said, okay, so let me ask you, when you are an arbitrator and you're at your firm in your office building, and you still do the hard copy way, you have a courier, like I just said, coming with DHL, FedEx, Aramex, God knows what have you, to deliver the submissions, right? So let's say that the claimant comes with the statement of claim and all the exhibits, and there it goes. And then you sign for that, and you get all these boxes, just like now the food is being delivered, right? Food over blockchain, that's where probably we're going to be in 50 years. Anyway, and so that's how that's done, right? Then we went into the modern era where we say, okay, the institute will get, let's say, the statement of claim plus the exhibits electronically, and the institute can distribute that. So these engineers looked at these stupid lawyers, me, and said, so, okay, wait a second. So the hard copy actually isn't secure because you're going over roads and God knows what have you, and you have this courier and you don't know. That's not secure at all. But email is definitely not secure. It's so easy to hack. And then they said, so what is your hesitation with blockchain? And we said, well, we just don't know it. So that's how we lawyers are. We don't like change and we don't know it. So they said, as these outsider engineers said, we don't understand how you jump from hard copy to email and you have no concerns about security, yet you reject blockchain. So blockchain, what blockchain does, it's also a carrier, it's a ledger, it's a computer protocol where you can just storage and transfer information. And so let me get this book, yes. So this is the blockchain virtually, and then it's a blockchain, right? So the institute, so let's say the Mumbai Center will have the blockchain that they can use as a server. So it's almost like I buy a computer program, like I buy something from Apple, yeah? So you buy a blockchain as a server, and you get your statement of claim, and you get your, I have to just load it, and you get your award and everything, and you store that on your blockchain ledger, the carrier, the block of change, chains, okay, pronounced. And this is all electronic, and it's stored on your blockchain. Now, why is this really good? It's extremely secure. Nothing is 100% safe, but this is far more secure than any other electronic internet ledgers, carriers, platforms, whatever word you will use. So it's safe. This is now my banana award is safe. My virtual electronic award. It's going to be a meme like you don't want to know. Anyway, and then it's there, right? And so then you say, I'm looking now at, I can see some of the listeners. So let's say you are counsel, you are claimant, you are respondent, you are arbitrator. But this ledger is with the institute, and this award is with the institute. And it's very secure, and it's original. Now, the good thing is, how do you access it? You each get an original key, and with that original key, you can access the virtual award, which means it's safe, you get access to the original, and you cannot tamper with it. Now, why is this so important for Article 2? It means that the moment the arbitration agreement and the award are stored on that blockchain ledger, security, everybody has a uniquely encrypted key. You have the original, you can't change the data, you can't lose the data, which means we no longer deal with all those certification and authentication and God knows what have you problems. And maybe also we're much more protected against cybersecurity. Okay, now I can breathe. So this is really my best way. Alexander Fischetti, who is really behind this blockchain for arbitration, so not Bitcoin, but blockchain for arbitration, is the superstar who made this whole thing. So I'm indebted to him. Now, okay, so there we are. And so let's be cynical again. So I'm trying to now say institutions need to have this blockchain. They need to keep everything on the blockchain. And then we will have tackled all these problems that I just spent an hour setting out. And now the students would have to ask all these questions. Yes, but, because we're lawyers and we're cynical and we don't trust anything and we don't trust anything new. So what is now the problem? People will say, well, how safe is it really? We're reading all the stuff about Bitcoin. The engineers will say, actually, the internet cost so let's say I now have my internet bars for the Zoom, it's working. But when I log into Ansitrol, they have a different IT platform that they use, and my internet isn't strong enough. So apparently to have an internet that can support the blockchain, you have to have a really good one. And the cost of that can be even higher than hard copy. So that's a but. The second is that some people say now it is proven that the blockchain isn't that secure. So we have already the cynical reactions out there. And then the question is, and this is what we have not yet figured out, which is, well, wait a second. Let's go back into the New York Convention. The New York Convention demands an arbitration agreement in writing. So I just said in writing, yes, we have these Ansitrol recommendations that say, well, it could also be an electronic way of communicating. But if you do a blockchain, how is a blockchain in writing? So if we're going to say these parties just put the arbitration clause into the blockchain, it's entirely virtual. So we're again hitting a wall there. So although it's so much better, we're having this really old text from the time of faxes and telegrams. For Article 4 says you have to have an original, but so only if you have a copy, you would have to certify it. Now, we no longer have copies because we have access to the original, but then if you have an original, the signatures still have to be authenticated. How do you do that? I don't know. Second, the parties and those involved have a uniquely encrypted key to the award and the arbitration agreement, and it's on this ledger. But what if you're going to enforce in 5 different other countries? How do you get it to those courts? And this is again where we see, just like with the pandemic and everything else, not all internet connections are created equal. Not all institutions have the same platforms, let alone courts. Like, do courts then have to have a blockchain? So if I would say now, the New York Convention has a lot of problems. There is the rise of technology. With the rise of technology, we see cybersecurity threats. We see all the geopolitical developments that throw us into this virtual world, but that also expose us to all this hacking and God knows whatever. We need to have changes. In comes the blockchain. The blockchain is amazing. We know that the ICC was very interested and they wanted to learn more about this. The blockchain addresses this problems of cybersecurity. The blockchain addresses the issue of don't lose your original, don't change your original. But like always, and this is where we get stuck all the time, the law doesn't move fast enough. The world is changing every single day. You wake up to a different world this week. The law isn't going fast enough. So the question that we are left with, and that's where I kind of want to pause it, is I think the blockchain is something that we need to be open to. We need to have an open mind. It could resolve certain challenges under the New York Convention, but somehow we can't avoid that reality that even if we have this great solution, the text falls short and it's words, and you cannot change the sun from yellow to purple. And so the question comes again, would an Ansitrol recommendation be enough? Can we do guidelines? Or should I just give the assignment to your students to rewrite the New York Convention? And I've almost lost my voice because I'm just too loud. So I think this is a good moment to pause. And maybe I'm hoping there are questions I cannot answer.
Okay. Thank you so much. Thank you. This was a great journey of sorts that you took us on, especially about contextualizing blockchain for us to be able to comprehend the challenges that are now faced with respect to using the New York Convention for enforcing or recognizing these awards. There are some people who had questions because I got prompts in my personal messages about doing question answers. So what we'll do is I'll hold the questions that I have and we'll allow our audience to ask questions first. And I will say hi to George. Marika George is online, I think. So hi, George, how are you? And yeah, we can maybe The ones who can see the raise hand function, please use the raise hand function so that we can call on you and then you can unmute yourself and ask your question. If you're unable to do that, have an unstable connection, you can just type in your questions on the chat. The chat is now open and we can relay those questions. So please do ask your questions. Yes, Pranav.
Yes, good afternoon, professors. Am I audible? All right, so I have actually a couple of questions and I'm only a first year student, so pardon any lack of knowledge on my part. But one of the questions that I had was, how does so you talked about how the New York Convention was an international statute that was basically there to, increase the legitimacy of arbitration across countries and to convince countries that to go down the path of arbitration. I was confused as to where the New York Convention or how the New York Convention derives its authority. Like, do countries have to be signatories to the convention, or like, so say for example, if there are 5 parties to, or let's keep it simple, there are 2 parties to an arbitration agreement, and one of the parties belongs to a country which has, let's say, not recognized the convention or something like that. So like I'm a little unsure of how it derives its authority, any of these awards.
Okay, so this is actually a very interesting question because there is the theory and the reality. So how it works is the following. The New York Convention is an instrument of international law. It's a treaty, it's a convention. So it was concluded in 1958 at the United Nations headquarters in New York. At the time, there was really only a handful of states present to negotiate that text. And I think on the day of the conclusion in June 1958, I think we had about maybe 20 states who in that moment decided to sign on. And then over the last 60 years, we have almost 170. So what is important step one, is that there are 170, I'm rounding up the number, parties to the New York Convention. So these are states who have said, we want to promote arbitration. We want to give arbitration legitimacy. We are signing on, we're saying that we want to be bound by that treaty. And so that's how you start with promoting arbitration. However, and this is where the New York Convention is so different from many other treaties, the New York Convention has to be applied by national court judges. So in most countries, that meant that once the executive has signed on to the New York Convention, the legislator, which happened in India also, has to implement the international treaty into national legislation. So that is the implementation. So what happens is the legislator takes that treaty and makes sure it becomes part of national law. And that is how the judges can apply it. So let's say you have one party to the arbitration agreement in the Netherlands that is a party to the New York Convention, and the other party to the arbitration agreement in India that is party to the New York Convention. They should be good because in both countries, it's been implemented. In both countries, the courts apply the New York Convention, but there are many differences in how it's effectively applied, I have to say that. And this means that if let's say you have an arbitration where the award was rendered in the Netherlands, you can go and enforce it in India. Now, there are still countries who have not signed on to the New York Convention, like, for example, Suriname, which is where, in a way, my family is from. So you cannot enforce an award there. There are also countries where, I think this was Tanzania, where let's say the executive, so the president, prime minister, minister of foreign affairs, whomever has the authority, had signed the New York Convention. So on paper, Tanzania is a party to the New York Convention, but it has not, the legislator has not enacted the New York Convention. This means that judges are not allowed to apply it. So if you want to enforce an award in Tanzania, you just can't. In Saudi Arabia has signed on to the New York Convention, has technically implemented the New York Convention, but the judges just don't apply it. The judges don't apply anything that originates from the international space. So the most important thing that I always say, yes, there is legitimacy on paper with 170 contracting states, but what I always say is you have to look locally. So wherever you're going to have your seat of arbitration, better be a New York Convention state. And then where you're going to enforce, don't only check whether it's a party to the New York Convention, but also check if it's implemented and if judges actually apply it. I hope that helps.
Yes, Professor. So from what I understand, the country or the legislature of a country recognizing, the statute is the prerequisite. And after that, there's another step that the judges need to enforce it. So it's not enough in itself.
Yes.
If I'm understanding it correctly. But then again, I had another query. Should I go ahead with it later, or is it all right if I go?
You can ask it. Maybe I can answer it.
All right. So from what I understood, you talked about the existing paradigm of how arbitration works. Like we have email. Earlier, we used to have the fax system. Now we have communication over email, and now blockchain might be the next step. This is not so much a question as I want to confirm if I understand it correctly. Blockchain doesn't solve any problem, so to say. It makes security, like the security aspect of it is arguably much better with blockchain, but the convenience aspect of it, there's no real change from the email system, right? I mean, it's still digital, it's still online.
So it is different from the email, but again, I've also just learned. So it's different from the email because the email, which is a way of getting information from one person to the other, right? Or let's say through an email, you send a document which you can then store on, let's say, a Microsoft storage or iCloud. So it is a same in the sense that it's electronic, but what we've learned from the engineers is that blockchain that also allows to send over information and then keep information electronically, blockchain is much, much, much more secure.
All right, Professor. Thank you so much.
You're welcome.
Thank you, Pranav. We have another hand up from Tamanna. You can please unmute yourself and ask your question. Thank you.
Thank you, Professor. So, good afternoon, Professor. I had a doubt that to ensure that the dispute resolution that happens on blockchain for blockchain users, I think they use something called the scaling point. But in that, there are economic incentives involved for the jurors. So my question is that even ethical? Like, should there be a monetary incentive for the jurors giving a judgment on something like this?
What was it? The Skelly point?
The scaling point.
Oh, scaling point.
Where the, yeah.
But how, I'm just kind of confused. Jurors, how does that relate to arbitration?
So that is arbitration on blockchain, right? Dispute resolution on blockchain. But
there are no jurors. Did I hear jurors?
Yes, I meant the people making the decision on blockchain.
Oh, that's the arbitrators, yes. Okay, yeah. It's the arbitrators. So, the arbitrators, so now let's say, let's go back before the pandemic. The arbitrators are in their offices, they're getting all the statements, and then there is an actual physical hearing, which is the oral phase, and then they go back to their desks and they write an award. And then that award is either sent by courier or email to the institute. If most arbitrations are institutional. Here, what you would have is actually really the same. You would still have the arbitrators writing their award on a computer, sent off to the institute, and that's then stored on a blockchain. So really, from the arbitrator's perspective, there is nothing different. It's just that when they hand over the award to the institute, which has to have it, and then you need it for enforcement and maybe setting aside governance, what have you, it's just more secure. But in no way will it influence how arbitrators would do their decision-making. I hope that kind of answers the question.
Yes, Professor. I had one more question. So since it has not been widely recognized yet, how will the awards be binding on parties? Like, how will they enforce it?
Yeah, so this is where we're now at a crossroads, because the award is binding. So what I mean with that is the minute the arbitrators have written and signed their award and handed over to the institute to put on this blockchain, that award is binding. This is also what the New York Convention says. An award is in principle binding and should be recognized as such. Now, if only the world would be that pink, because the issue is that the award is binding, no matter if it's typed on a typewriter or it's done by the arbitrators on the computer. We do have an issue with electronic signature. It's more in the enforcement. It's not so much the award itself. It's the issue is Article 4. So Article 3 says the award is binding, but Article 4 talks about the way to show that award to courts. So Article 4 says you have to have the award and you have to have that signed and you have to have all sorts of stamps on it, and that's how you get it to the court. And so it's more the how do you deliver it? How do you package it, right? And that's the problem where, one, we now see that the signatures are often just electronic and not actual signatures. And two, we see that these awards have been sent over electronically, whatever. And so how then do we do that whole certification authentication process? And even if you have the hard copy award, how do we do the certification and authentication process? Now, on the one hand, the blockchain is great because you no longer have to worry about copies. You just have that document on the blockchain. The problem what we're now faced with is how do you then match that with Article 4? So where I want to get to is the arbitrators draft their award, they do an electronic signature, they press send or whatever, they get it to the institute that puts it on the blockchain. And if ever anybody needs to have a look at that award, it's right there on a blockchain. You can't lose it, you can't change it. The problem is that Article 4 is written 60 years ago and still wants this old-fashioned process of authentication for a signature. So the issue is that we're just not there yet. And that's what we're trying to figure out, that if institutions are willing to say, yes, we want to use the blockchain, we have solved the problem of copies because you no longer need a copy because you have access to the original. So you don't need certification, but you would still need authentication. And then the courts might say, well, we don't want a uniquely encrypted key. So again, we're left with sovereignty of how each court of all these 170 contracting states, how are they going to react to a blockchain? And so for that, we would need those UNSOL recommendations. So a short answer is we haven't figured it out yet. This is really new ways of arbitration and law in the making as we speak.
Thank you, Professor.
Thank you, Tamanna. We have more questions. I think this is Professor Mansi, who's our colleague here at the Jindal Global Law School.
Yeah, Akanksha, there are a couple of students I see whose hands have gone on. Please take the students first.
All right. Thank you so much, Professor.
Thanks.
Yeah, so we can maybe go with Harshit Jain. You can unmute yourself and ask a question. Thank you.
Good afternoon, Professor. Professor, how do we understand the concept of natural justice and international law if we are really keen to know the wider concept of law and justice in a globalized world? Because I am really interested to know about the subjects such as insurance law, cyber law, natural resource law, environmental law, animal welfare law, and national security as well. Because these are the subjects I want to know. I wanted to know the changes which we are witnessing all around the world, and there's an immense need for application of law in these areas. So the question which I wanted to ask is, how is natural justice and international law go hand in hand to sort of make us know that how law and justice in a globalized world can really make a difference at large?
That's a very profound question for a Saturday morning. And I know George Botan is also listening. So I think he knows more than anybody on the call how I feel about this right now, also after yesterday and the day before yesterday. Trying to be diplomatic here. So at the beginning of my lecture, I set the sort of broader stage of there is the history of law with respect to the New York Convention that is part of international arbitration, part of international law, and comes after the ruins of World War II, has been applauded by somebody like Kofi Annan as contributing to peace. And I told you that there are even those who wanted to submit the New York Convention and its father as a potential candidate for the Nobel Prize. But then I segued into the sort of the sarcastic picture painted of where are we geopolitically? And I segued into Trump and everything that happened after, and the pandemic and the humanitarian crisis, and how we see the limits of governance, and where I give this comparison of Falinarium of the billiard balls that collide often and seldom do they go in the same direction. So my personal view is that natural justice is a concept that we can be very philosophical about. But at the end of the day, it really depends on what law is ultimately created by stakeholders. And the stakeholders fall into two buckets. One is stakeholders in a country. So that's politics, but it's national politics. So it's whomever you've elected into cabinet. So the head of state, the prime minister, the cabinet. So that would be Biden, but then also all the secretaries, Secretary of State, Secretary of Health, Secretary of Defense. And then you have the checks and balances of a democracy where there is a Congress or there is a parliament to hold a government accountable on behalf of its people in democracies. That's the domestic space. And you then depend on those stakeholders and policymakers to do the right thing in terms of what is justice. Then the question in the domestic space is how is it enforced? In the Netherlands, that seems to be a sound democracy. We've seen an unbelievable denial of justice, and maybe even to the point of its human rights violations, where many parents were accused of tax fraud, unrightly so, and it threw thousands of families into bankruptcies because of a result of politics. That's that bucket. Then you have the other bucket, which is at the international level, which is the United Nations, which is UNCITRAL, which is the World Health Organization, which is the World Trade Organization, which is multilateral conventions. And we've seen waves, right? We've seen everything post-Trump. We've seen where we are now. We've seen the situation with Afghanistan and the negotiations that take place next door in Qatar. And again, I'm sort of virtually looking at George. We have the Working Group 3 where sort of the whole idea of investor-state dispute settlement is up for grabs. Sorry for sounding cynical. And then what we see is we have that international bucket that's been sort of going from one direction to the other over the last 10 years. And so we have that national bucket where we get back to a game of pool where the billiard balls are colliding all the time. And so we are light years away from the idea of natural justice, because it really depends on what's happening at the UN and all its entities, from UN Women to UNCITRAL. And then we flow into the national space where we don't even know what happens, and that's where your vote counts. So sadly, the answer to your question is that we have to depend on our right to vote and whomever ends up in government to do the right thing, which with the global pandemic, we will only be able to say after the fact, was it done and handled the right way in each country? And then we have to depend on our leaders to come together in that international setting, let's say the United Nations, to again do the right thing. And what I've seen in the United States, and obviously my firm is led by Madeleine Albright, but also what I've seen with UNCITRAL, I I'm left with nothing but cynical sentiments. And I don't want to end with answering a question like that, but I do think that what then becomes very important is that we still fight back. We make sure that our voices are being heard. We engage with the right stakeholders. We engage in advocacy to really go back to that original concept of what is justice for people. And today is the hardest question to answer. That's why I really took my time to set out where we are geopolitically. Hope that answers the question. It's a hard one.
Thank you very much, Professor.
Thank you. Can we go with the next question, Disha? Disha, you can ask your question, please.
Good afternoon. So my question is something on the lines that has just popped up in the chat box. I think it's very similar to what has come up. So when we talk about the loopholes in the New York Convention and how it's not keeping up with the times and the technology that is being advanced, how do you think is the way to fill in these gaps? Do you think merely arbitrators having a broader interpretation approach, arbitrators recognizing these methods is enough, or do you think a formal mode of recognition will be required?
Well, so here's what I try to emphasize is that actually it's not really for the arbitrators. This is a problem for judges. This is a problem for legislators and policymakers. So the irony of the New York Convention is that everybody places it within the arena of international arbitration, but it has in a way nothing to do with the practice of international arbitration. And what I mean is the following. Although the rationale of the New York Convention is to promote international arbitration as a good way of resolving disputes in international trade, so it's about those parties based on party autonomy opting for arbitration, giving up their right to fundamental access to courts. And although it's the arbitrators who are resolving a dispute, once they have rendered their award, they're done. And they're rendering their award on the basis of the arbitration agreement and the contract and the lex arbitri, so the arbitration law of the sea. That's all those arbitrators think about. Now, the good arbitrators obviously want to render an award that cannot be set aside and that can be enforced. So sometimes we say, write a due process proof award, write an award that's really based on that arbitration agreement, that's based on that mandate, where the arbitrators are appointed on the basis of the arbitration agreement, where the arbitrators follow the lex arbitri, where they comply with due process. And so whenever they sign off that award, they have done their job. But really, this is all about the courts. So the problems of the New York Convention cannot be solved by the actors in the arbitration procedure. The problems are thrown on the desks of the national judges. It's the national judges, and this is why it's an international instrument that is so odd, because it's an international instrument that in its impact is national. So it's national judges in 170 countries that have to apply that text. And so you have to understand, and these are mostly lower court judges. So these are judges who are doing everything, from contracts to labor to this to that, and then every now and then they find a New York Convention request, and all of a sudden they have to look into this treaty. And I need to check if this agreement is in writing. And this is where we see a problem. Now, some countries have resolved that by having a specialized court, which is really good. We wrote a guide. So this has, we made checklists, they're somewhere. So we made a guide for judges where we sort of rewrote the New York Convention in a way that it's easy, accessible for them. And then for everything that we made a roadmap. And then for everything that they need to do, we made a checklist. So that has helped. But even with all of that, specialized courts, the guide, answer recommendations, in order to allow all these judges worldwide to have a pro-arbitration attitude, I still think we need a new treaty.
Right. And I think with that, I can segue into saying that we will confirm the dates for the next topic, but we will get Prof. Marika to talk about reforming, revisiting, rethinking the New York Convention. So we can maybe then, Disha, I hope that answers your question.
Yes, thank you so much.
All right. Thank you. Prof. Mansi, you can ask your question, please.
Hi, thanks so much. This was a really, really fascinating talk. My question, I especially wanted to keep it at the end because I'm not sure I also understand blockchain. I absolutely feel no sense of confidence about this technological revolution we're all in. But one of the things you mentioned, Mary Kay, in your explanation of blockchain and smart contracts was it just piqued my interest. You said maybe there's no need for courts. There was this little stray sort of clause in there, and I was wondering, was that referring to some possibilities in the future for some simpler disputes being resolved through an artificial intelligence? And if that, then wouldn't that need a separate convention? Because it wouldn't be arbitration in the sense that arbitration is actually defined. It would be something new. So I was just curious about that. I mean, whether you could just.
And so this is where, and again, I'm also having high anxiety levels about this new world. So just like Bitcoin, which I don't know anything about Bitcoin, first is, but apparently what blockchain can do, it can cut out the intermediary. So apparently in our daily lives, when we participate in commerce and God knows what have you, we work with intermediaries. So really old school, when you used to keep your savings in a sock under the bed, which I've never done, but we put our money in a bank, right? And our bank sometimes invests for us or does this or that, or God knows what have you. And so that's why people move to Bitcoin, because you cut out the bank. So apparently what this ledger does is it can cut out the intermediary, and apparently it can dispose of courts. Again, somebody still needs to break down to me how exactly that works, but where we are then, how I understand it is the following. You can have smart contracts, which this group has developed, which is like a tech contract that can then be kept on that blockchain. And then if there are disputes, you have everything on the blockchain. And like you say, you add artificial intelligence to resolve those disputes, and whatever the outcome is, it's on the blockchain. So you're cutting out everything that's real, right? Judges, people, God knows what have you. I know from sort of the community of international arbitration, you have Professor Catherine Rogers, who we should definitely invite to also join one of these lectures. She is really the leader on artificial intelligence. She's the absolute expert. She's worked on this for years. She collects data, does empirical research, God knows what have you. And so it's there, the writing is on the wall. We will have to understand that, like you say, maybe for smaller disputes, you can use artificial intelligence instead of an arbitrator. So apparently you can create, I guess, algorithms and I don't know what.
Yeah.
And it's this artificial intelligence robot or something that resolves the dispute. And that is done on the basis of an original Samba of smart contract. And everything is then, the ledger is blockchain. Now, I'm already, I don't know what's the words are coming out of my mouth.
But if we take that sort of hypothetical, because you and I are on the same page. For us, we don't quite wrap our brains around it. I that's okay. But would the New York Convention then apply? Because the New York Convention deals with arbitration, which is defined as individuals who are sitting, and so the measures, even the standards of appeal are narrowed because there's a certain autonomy, a certain discretion given to these individuals, these human beings who are deciding the matter. Now, if it's a pre-programmed algorithm that is deciding the matter, I just imagine that a whole new convention to take into account all kinds of different, even appellate standards is going to have to come about.
So I had a professor from Brazil who asked me a week ago, Marika, do you think that decisions that are the result of artificial intelligence, do they fall under the New York Convention? So it's a question of scope. So Article 1 of the New York Convention regulates the scope, which basically says a foreign award or an award that's considered non-domestic or an award that's rendered under the auspices of a permanent arbitral institution can be enforced under the New York Convention. And so they did not define award. They did not define arbitration. If you look at the drafting issue of the New York Convention, the delegates said, let's not define that because for each country it will be different. Then you see a lot of case law developed of what is an award, what is an arbitration, and it has a very big gloss over it. Like, gosh, everybody knows what arbitration is. Everybody knows what an award is. And so the question became, okay, permanent arbitral institutions, yes, but would an award from the Iran U.S. Claims Tribunal fall under the New York Convention? Now we have a question. If the Working Group 3 of UNCITRAL is going to have a world court for resolving investor-state disputes, would that fall under the New York Convention? Now, these questions are light years away from, would an artificial intelligence robot award fall under the New York Convention? My cynical answer would be no, this is going too far. This is really where we're making the yellow sun into, purple with green spots or something. And so I think, unless you just say, let's just be really practical, but then like you say, if you work that through, Article 5, the refusal grounds, due process.
Yeah.
How are the arbitrators appointed? I think that if we're going to go there, so we have smart contracts, blockchain, artificial intelligence, come on. If we are willing to go to that level of modernization, we have to go in and get a new treaty. That's what I think.
All right. Thank you very much. This is really fascinating.
You're welcome.
Thank you. Thank you. Thank you. Are there more questions? Are there more questions? All right. Maybe then I can ask the last question. There's about 5 more minutes. And I'm going to bring up something that is my favorite part of what you write, which is Article 6.7, what you call the trump card, unfortunately. And I wanted to ask you that we've been talking so much about blockchain and maybe the potential of self-regulation at the moment because New York Convention is not as forward-thinking or maybe cannot be applied that far. However, what if there is an internal legislation already that recognizes blockchain transactions, blockchain contracts, has figured out internally a methodology to at least locally enforce outcomes from blockchain transactions? Wouldn't that become a more favorable right that then becomes part of the New York Convention channel? That's my first question, which will bring me to another question that has been asked in the chat to me, and we didn't, I could bring it up earlier, which was also that what if a country does not recognize something like cryptocurrency or Bitcoin and categorically de-recognizes such a transaction? What then of a party belonging to such a country in a contract where a law, substantive law that applies is a law different from their home nation's law, which doesn't recognize Bitcoin? How then do we start thinking? Can we start thinking of maybe a way for the New York Convention to still become applicable through Article 7, the more favorable right?
Okay, so the first question, the answer is yes. So this is really the beauty of the New York Convention, is that if there's anything more favorable, whether it's a treaty or national law, you can opt out. So what we've now seen after the New York Convention was drafted in 1958 and the world was advancing, UNCITRAL, that's sort of like the successor of ECOSOC, said, okay, we need to modernize or harmonize international arbitration. So they created UNCITRAL model law, UNCITRAL rules, etc. And so many countries have adapted the model law and based their arbitration legislation on the model law. And that one, when it comes to in writing, is far more aligned with the actual practice than the New York Convention. So for Article 2 already, you see that you can opt out through Article 7 and go to the national legislation based on UNCITRAL. So if there are national laws that are ahead, in terms of blockchain, etc., you just rely on that. There is a question of cherry picking, because then you're opting out of Article 2, and this is Action 1 recognition arbitration agreement.
Exactly,
but,
yes.
For the enforcement, you're still with 3, 4, and 5. So this will still be a problem. Then, if you have a situation where, let's say you have let's say hypothetically you have an award on the blockchain, so you're not some cryptocurrency, whatever modern award, and you want to enforce it in a country where there are actually laws, like you say, that don't recognize that. You end up in the public policy bucket of Article 5.
Exactly.
So where a country could say, wait a second, here's where we draw the line. The only things what we see with the case law under Article 5.2 is very limited. So there's really no right public policy to fundamental notions of morality and justice. So there are ways within the New York Convention, but I remain stubborn that we still need to revisit the concept of the New York Convention.
Of course. And which is what, I mean, why I tried to extrapolate it was that if Article 7 is being used to somehow trump the in writing requirement, can we then stretch the provision so much to completely do away with the writing requirement on blockchain?
Yeah.
And thereby then at least not have that it is not in writing ground for refusal.
I think once we go there, we are actually telling judges, just look at the New York Convention as a framework, like some inspiration.
It's a guideline now.
But
it's a guideline. Yeah.
It will no longer be proper treaty interpretation of a treaty. That's what I think.
Okay. Thank you so much. Thank you. If there are no more questions, I think I've taken almost everything that was on the chat box. Yes. So if there are no more questions, Ashwin, do you have something that you want to ask? Anything?
Not particularly. I think all the questions I wanted to ask, I was putting together. Mansi ma'am and you together covered it. So I really have nothing else to add.
All right. Thank you so much. So thank you, everyone. And thank you, Prof. Marika, for agreeing to do this. We'll have you back soon. And hopefully we'll have you back soon for more. Right. Thank you, everyone. Thank you for making time on a Saturday. Bye-bye. Take care, everyone. Thank you, Ajay ji. Ajay ji, you can stop the live stream, please. Thank you.